In our last session, we talked very little about something called pilot judgments. And before we start going through the cases, I'm going to go through a number of cases of European Court of Human Rights that protect specific rights, the right to free speech, the right to freedom in religion. But before we get to that, we're going to talk about something called pilot judgments, which over the past few years, the European Court of Human Rights has developed, and it's a new procedure that means that allows them to deal with large groups of identical cases that derive from the same underlying problem. The court has had for some time a problem with too many cases that are identical. So if you are having, for example, 20 cases coming out of Greece that have the same identical issue, the court will identify that as a legislative issue that the country has. So they'll try to lump together the cases and handle them as one, and then bring that to the country that the cases are arising from and say, look, we are making a decision on all of these cases, but the resolution for this is that you look at your legislation and you amend it and you come back to the European Court of Human Rights and you show us that your change in legislation resolves the problems that these 20 cases have brought up. So when the court receives this large number of cases, it can take each one as a priority, but when it deals with a whole group, the resulting judgment is called a pilot judgment. So it doesn't answer the specific cases problem. It answers the problems of 20 or 30 or 40 cases that are all having the same issue. So the point of this judgment is, one, to determine whether there's been a violation of the convention in the particular case. Two, to identify the dysfunction in the national law that is the root of the violation. Three, to give clear indications to the government as how it can eliminate this dysfunction. Four, to bring about the creation of a domestic remedy capable of dealing with similar cases, including those that may already be pending before the European Court of Human Rights, or at least to bring about a settlement of all such pending cases before the court. Therefore, the pilot judgment is intended to help national authorities to eliminate the systemic or structural problem that's been highlighted by the court and that's giving rise to repetitive cases. In doing this, it assists the Committee of Ministers to ensure that each judgment of the court is properly executed by the state. An important feature of the procedure is its possibility of adjourning or freezing the examination of all other related cases for a certain period of time. So when they identify that this is a national issue, it puts all of the cases that are coming forward in a freeze situation where they're going to now await a resolution by the national government. This doesn't mean that the European Court of Human Rights just lets go. The European Court of Human Rights, the European Council monitor what is happening in that country and how they're dealing with this legal issue. They will have, the members of the committee will be filing reports, deadlines will be set, and if they fail to meet those deadlines, it will again be brought before the European Council, and again, if necessary, it'll be brought back to the European Court of Human Rights, and some sort of measures will be taken either by the court or by the commission. I'm going to show you two cases that we're going to go through. The first is going to be a successful one in Poland, and the second is going to be a not very successful one under the pilot judgment in Ukraine. So at any point of time, the court, if it feels that there's a failure, can resume. But it will take numerous interventions by the European Council, usually before it's brought back to the European Court, because there is a desire to resolve it outside of the European Court of Human Rights, as it saves enormous money, resources to get the country to deal with the national issue rather than have the court go case after case after case. So the very first pilot judgment procedure was a case called the Bug River cases that arose from Poland. So I don't know if it's going to translate, but it's Bug, B-U-G River. It's a name of a river in Poland. The court was able to monitor the operations of the procedures in other cases and has been able to basically establish the whole pilot judgment system out of this Polish case. So what were the Bug River cases? They were cases that came out of claims by Polish citizens for land, houses, property that had been in Poland in 1945 after the war. And these were lands that were redistributed to Ukraine, Belarus, and Lithuania. The Bug River runs through the land, which is the reason for the naming of this big lump of cases. Due to the unsatisfactory handling of the matter in lower courts, it was raised before the Polish Constitutional Court in 2002. In 2004, the matter came before the European Court of Human Rights. The test case, the first case, was called Bronowski, Broniowski versus Poland. The court found a systematic problem, and I'm now quoting from their decision, a systematic problem connected with the malfunctioning of domestic legislation and a practice caused by the failure set up of an effective mechanism to implement, quote unquote, the right to credit of Bug River claimants, with the consequence that not only the applicant in this case, but a whole class of individuals had been or were still denied the peaceful enjoyment of their possessions. The court noted that the matter was not satisfactorily resolved for 80,000 claimants. So if the court did not handle this now as a lump thing, looking at the national legislation, it would have meant that the European Court of Human Rights would have had to deal with 80,000 claims that were almost identical. So in February 2014, the Polish president signed a decree to update the regulations relating to compensation for Bug River landowners. In particular, the decree removed a number of restrictions on the right to compensation. In so doing, it addressed the issues before the Constitutional Court and the European Court of Human Rights on the subject. The pilot judgment procedure addresses the court's excessive workload, but it also dealt with defects in national legislation. So this was the first case that the European Court of Human Rights established the concept of pilot judgments. Now I'm going to discuss a case where it used the pilot judgments, and it's an example of the challenges that the court faces in implementing pilot judgments. And this is the case of Yuri Nikolaevich Ivanov versus Ukraine. And this was the first pilot judgment against Ukraine, and exemplifies the challenges, and especially the challenges that the court has faced in dealing with judgments against the Ukraine. So Ivanov was a retired military officer from the Ukrainian army, and he was entitled to a one-time retirement payment and compensation for his uniform, but he didn't receive it. And it was only an amount of 800 euros at the time. But over a number of years, he pursued it. He went to the first court to attempt to enforce the payment. And in each time, he was told that he was owed this amount, but at no point was he actually given the amount. So in April 2004, more than 2.5 years after his original judgment saying that the military owed this amount to him, they informed him, the bailiffs of the court informed him that they did not have the money to force it because they could not force the sale of assets belonging to military. And that was prohibited by law. So there was no way that the decision that had been found for Mr. Ivanov could be enforced. He continued to lodge complaints in court. He did not stop. So it continued, and they found the bank accounts that they were trying to freeze of the military, but still there was no resolution to this. It got into the European Court of Human Rights in 2009. So in 2009, the European Court of Human Rights ruled that the remainder of his initial judgment, as well as unenforced judgments and compensation due to the delay of over 7 years, were due to Mr. Ivanov. During the decade pursuing this, the European Court of Human Rights realized that there was an emblematic problem here, an obstacle faced by all Ukrainian citizens in dealing with the national legal system, and that was the enforceability of judgments. So the European Court of Human Rights found violations of Ivanov's rights, and it noted that so many similar cases were being brought forward that the Ukraine had repeatedly found violations of Article 6 of the European Convention of Human Rights, which guarantees the right to a fair trial, which includes enforcement of judgment. While the defense, the Ukrainians, argued that there was a failure because of inability to access the funds and an omission on the part of the bailiffs, the European Court said that these factors were not outside the control of the authorities and that the state was responsible for the violations. The court quoted judgments, and it put on a number of judgments, including a case called Burdov versus Russia. And they stated that according to Burdov, the burden to comply with the domestic judgment regarding enforcement lies with state authorities. So it realized at this point that the non-enforcement was a long-standing issue in the Ukraine, with roots in several aspects of Ukrainian legal, judicial, and political system. After discussing the individual merits of the case, the European Court of Human Rights decided to apply the very first pilot judgment procedure against Ukraine, citing the recurrent and persistent nature of the underlying problems, the large number of people affected by them in Ukraine, and the urgent need to grant them speedy and appropriate redress at domestic level. So what happened is the case then comes back to the Ukrainian government. So there has to be a change in the legislation. The pilot judgment set out specific conditions and deadlines. And this is one of the essential things with the European Court of Human Rights, that it's not just handed back to the country. There's a continuing monitoring by the European Council and by the European Court of Human Rights of what happens to that decision. So they were granted 1 year deadline to change the law, to create an effective domestic remedy or combinations of such remedies in order to address the delays that were happening in Ukrainian courts. The court adjourned proceedings and then waited, and they waited. And the Ukraine failed to take action. So the European Council again came forward, and I think it was, I'm just looking now what the date was. So there was a progress report in 2010, November of 2010, and the European Committee of Ministers evaluated the execution of the judgment and 386 other decisions. They reported that Ukrainian authorities had informed them of a draft law. So I won't keep going through this case, but this went on for years. They said that there was going to be a draft law, then there were problems changing the law, and it continued and continued. Finally, on December 2010, a month before the initial deadline set to expire, the Ukrainian government requested a 12-month extension. The European Court of Human Rights did not give them that. They gave them a 6-month extension through July of 2011, but noted that non-enforcement had not improved in this entire period. This went on, and in June, a month before the Ukrainian deadline, the European Court of Human Rights issued a report noting that the Ukrainian government had set forward a law entitled Guarantees of the State Concerning Execution of Court Decisions. This again went forward. The government refused to pass this law in Ukraine, but sort of at the last moment, there was so June, the president of Ukraine signed at the very last moment before the European Court of Human Rights came towards him. The president of Ukraine signed the bill, the draft bill, which there had been much objection to, into law. Why does this happen? Why do the decisions get there? And pilot judgments, which are meant to help the countries change the law and resolve numerous cases that are not only going to block the European Court of Human Rights, are going to block national systems. Because if you had the Ivanov case, as they said, they had 386 more coming through the way. They were also going to go through the Ukrainian court system. So scholars have identified several factors that influence governments' responses to pilot judgments. One of them is the state's capacity to reform. The issues in pilot judgments are by definition systemic problems in the country, and shortcomings in a national response are due in part to the complexity of addressing these weaknesses. A state's non-compliance with a judgment may be the result of voluntary resistance, where there's a conscious decision not to listen to the European Court of Human Rights, not to change their laws. Or it could be an involuntary resistance, where there's just not the political will, there's not the legislative ability or will to implement the judgment, but the state is simply not able to bring about the requisite changes. Now, why did I just spend, how long did I spend? 20 minutes discussing with you pilot judgments? First of all, because they're an innovative way to bring cases to the European Court of Human Rights. They allow an issue that is in your government, that's in your country, that is blocking your courts, that is not changing, to be brought before the European Court of Human Rights. So it allows, if a numerous number of lawyers get together, it allows the European Court of Human Rights to judge on national legislation in a way that right away demands, because of the volume of cases coming there, demands the country to address it. I am aware, I'm not speaking as this idealist. I know what the challenges are that you all face, but this is a way that allows you to really put forward an issue if you come together and make it clear that this is not a one-off case of a right being violated. This isn't a case, and when I was looking through detention, so many cases of immigrants all over the world being illegally detained, potential people just based on nationality being detained. This isn't a case of an individual. This is a case of when you use pilot judgments, of a systemic problem in a nation's legislation. So it's a way to bring that to the attention of the European Court of Human Rights, and a way to bring publicity, if only that, to the national issue at hand. So now I'm going to move on, and I'm going to discuss how the European Court of Human Rights has confirmed specific rights in Europe. First, we're going to look at a decision that defined an individual's rights. And this case is called A and Others versus the United Kingdom. And this case concerns the indefinite detention of foreign prisoners in the United Kingdom's prison called Belmarsh. The prisoners were all held there under Section 23 of a British law on Anti-Terrorism, Crime and Security Act that was passed in 2001. This decision and the subsequent decisions were challenged. The decision, they were found to be, they were challenged in the UK as being incompatible with the aims of the European Convention on Human Rights, which the UK is not only a signatory to, but was one of the drafters of. The original case was brought by 9 individuals who were threatened with deportation without trial on the basis that there was some evidence that the individuals posed a national security threat. The 9 challenged this deportation decision of the Special Immigration Appeals Commission. All 9 were detained under anti-terrorism, and this enabled them to be held indefinitely without any trial or deportation. This case is so important because it shows a direct challenge in the courts of the extent to which legislation confers powers to the executive in which ways they deal with a presumed threat to national security. So, as you're all aware, 2001, the bombings in the United States, terrorism in the UK, the executive authorities in the United States become strengthened to a point that they've never been before. This was under George Bush and Tony Blair in the UK. In the US, this went to the formation of Guantanamo, holding prisoners without trial, without rights to see their lawyers. And the same exact thing was happening in the UK. This was an emergency thing. They were found, the United States developed a new category that allowed them to not be part of the Geneva Convention, where they called people who they defined as terrorists as non-combatants, so that they weren't provided the same rights as US citizens or the same rights as any person who would normally be held under the Geneva Convention. Sadly, the executive rights that grew under George Bush also grew under Obama. He took them even further, and when we arrived at Trump, they were strengthened to a level that the U.S. had never seen. The same thing happened in the UK. So these powers allowed executive branches to take away normal rights that were always given to prisoners. So the case is so important because it shows a direct challenge to the courts and to the extent which the legislation confers power to the executive, and how they deal with something that they define as a national threat to security. The judges had to weigh up considerations of the power conferred by such legislation, the limitations on such power of the executive, and a balance of the necessity to limit personal liberty in order to protect national security. The ruling in this case was a landmark decision. The House of Lords in the UK held that the provision under which detainees were being held was incompatible with Article 5 of the European Convention of Human Rights. However, the Home Secretary was not required to release the prisoners. So the UK High Court found that this was illegal, the way that they were holding these prisoners without any trial, without any sign of when they would be released, any ability to get bail. Provision had the effect of discriminating between foreign nationals and nationals of the state. As a result, the Lords finding they made a declaration of incompatibility with the Human Rights Act, which is based on the European Convention of Human Rights. The judge stated the duty of the court is to check that legislation and ministerial decisions do not overlook the human rights of persons adversely affected. This case decision is so groundbreaking because it shows a willingness of the judiciary to check the powers and exercise of the executive in matters concerning national security. It's important to note, however, that the Lord's ruling and subsequent declaration of incompatibility did not render the acts of detention or application of Section 23 invalid, nor did it bind the actions of the Home Secretary. As such, 9 individuals remained in detention, and they took their case to the European Court of Human Rights. So even though they found, the High Court found this to be illegal, there was no way that they could change the actions of the Home Secretary, and the Home Secretary himself was not found to be guilty. So this case went to the Grand Chamber. So it rose all the way to the highest chamber of the European Court of Human Rights, and the decision was delivered in February of 2009. So we have an 8-year detention issue. So when the case got to the European Court of Human Rights, it upheld the view of the House of Lords, and it found that there was a violation of Article 5 on the same basis, and awarded some small sum by way of damages. The offending section of the Act was repealed in 2005, following the 2004 House of Lords decision. So the House had changed the laws prior to the case going to European Court of Human Rights, but the 9 individuals were still able to sue for damages for what had happened to them, even though the law had been repealed. So we're going to deal now with 2 cases very quickly, which I think will illustrate to you why it's called the European Court of Human Rights. So I'm a little bit cynical here. These are 2 cases that deal with religious freedom in Europe. The first case is called Refa Partisi versus Turkey. And this is dealing in 1998 case, in 1998 incident where the Welfare Party was banned from politics by the Constitutional Court of Turkey because it violated the separation of religion and state. The ban was upheld by the European Court of Human Rights, and the European Court of Human Rights decision was actually criticized by Human Rights Watch for lack of consistency, as it refused the disbanding of other parties on several occasions, but it did allow this. And of course, there's numerous commentaries about the special treatment of a Muslim case, allowing a Muslim party to rise up, and that the European Court of Human Rights allowed that to be banned. A chamber of the court found that there had been no violation of the applicant's freedom of association in the Refa case. This was the basis of their decision. The measure that Turkey took were found to be prescribed by law and necessary in a democratic society for the pursuit of legitimate aims. 3 of the 7 judges did file a dissent. They found the measures of the Turkish court to be disproportionate and government. On the request of the applicants, the case was referred to Grand Chamber of the Court. And on February 13th, 2003, 17 judges of the Grand Chamber upheld the previous judgment with no dissent, with 2 concurring opinions. So the Welfare Party, which was a Muslim-affiliated party, was banned from politics by the Constitutional Court of Turkey, and it was allowed and that was allowed legal by the European Court of Human Rights. The Rafa case is a modern test for the notion of militant democracy. It raises a question as to the range of policies and opinions that political parties may espouse under the European Court of Human Rights, Article 11 on the freedom of association. While the court chose to deal with the Article 11 case, the case is also of clear interest to those concerned with the right to freedom of religion or belief in conjunction with the freedom of expression. This is so not least because of the court's interpretation of key Islamic concepts, such as Sharia, jihad, its endorsement of modern Turkish secularism, and its arguments against the plurality of legal systems allegedly promoted by the Refa party. One of the main criticisms of the court has been that it challenges national sovereignty. The court has also been accused of protecting Western European values and being biased against Islamic traditions. Further, it passed a decision in the case called Leyla Sahin versus Turkey, a case that was brought in 2004 where a medical student challenged a Turkish law which banned the wearing of Islamic headscarves at universities and other educational state institutions. The court upheld the ban against the Turkish law by 16 votes to 1. So it allowed the government of Turkey to ban headscarves. On a very different side is a case called Lautsi versus Italy. And this was a case that was filed by a Finnish school teacher who was working in Italy in the Veneto district. She sued through the Italian courts because it is mandatory in Italian schools to have a crucifix, a cross hanging. And in the Italian courts, it went all the way to the highest court in Italy. It was found that this was not a symbol of, this was a symbol of their culture and their ethnicity. This wasn't a symbol of an imposed religious value. So this case went to the European Court of Human Rights. Um, a chamber of the second section of the court declared that there had been a violation of the European Court of Human Rights, European Convention of Human Rights, and that it was a violation of an individual right by being forced to look at a cross and have this imposed religion, even if you were not a Christian. This decision caused a big uproar in Italy and a lot of upset with the Italian population. In March 2010, the case was referred to the court's grand chamber, which prescribed the presence of crucifixes in state school classrooms, a sign which, whether or not it's accorded in addition a secular symbolic value, undoubtedly refers to Christianity. So the court, the grand chamber, so the highest part of the European Court of Human Rights, acknowledged that crosses hanging are not just a cultural Italian symbol, they are a symbol of Christianity, and that the regulations confer on the country's majority preponderant visibility in the school environment. However, it declared that this is not in itself sufficient to denote a process of indoctrination, which would violate, that would be a breach of Article 2, Protocol 1 of the European Convention of Human Rights. It added, a crucifix on a wall is an essentially passive symbol. It cannot be deemed to have an influence on pupils comparable to that of didactic speech or participation in religious activities. It protected the right of parents to ensure the education of their children. Article 2 protects the right of parents to ensure their education and teaching in conformity with their religious and philosophical convictions. Moreover, the court decided, for the reasons given in the examination of the rights of the parents, no separate issue arose under Article 9, which protects freedom of thought, conscience, and religion. Nor did the court find a separate issue under Article 14, which prohibits discrimination in the enjoyment of rights and freedoms set in the convention. So you'll see here that the European Court of Human Rights did allow the Turkish government to ban headscarves in order to protect a secular Turkey. But in this case, even though it said it was a Christian symbol, a cross hanging in every single classroom in Italy, it did not find that to be a violation of a human right, because it did not force people to become. So it's a very interesting, and you can't, I don't believe, ever take the fact that the European Court of Human Rights is in Europe, and that you are going to have an enforcement, and be it knowing or be it subliminal enforcement of European values. We're going to now look at a case that upholds the freedom of expression in Europe. And this is the case of Nagla v. Latvia. So Ms. Nagla was a journalist who produced and hosted a weekly investigative show on TV called De Facto. She was contacted by an anonymous source who revealed that there were serious security flaws in a database maintained by the State Revenue Service. Nagla announced the data leak during a broadcast of her show. 1 week after the broadcast, a person called Neo started to publish data through his Twitter account concerning the salaries of various public institutions, of various individuals at public institutions. The investigating authorities established that a person had been connected to the database, had also made several calls to Ms. Nagla's telephone. On the same day this person was arrested, Ms. Nagla's phone was searched, her data storage devices were seized, including a personal laptop. So Ms. Nagla complained that she'd been compelled to disclose information that enabled a journalist to be identified, and thus her freedom of expression had been violated. So by seizing her materials and her property, the Latvian authorities were able to arrest the person who had been leaking the information. And this was all done without her consent. So she went to the European Court of Human Rights after being rejected through her domestic courts in Latvia. And under Article 10, Section 1, she challenged the protections of, she said that the protections of freedom to impart information, freedom to receive information were violated. the court agreed with her. The court ruled that the search of Ms. Nagla's home and the seizure of her data storage devices violated her freedom of expression, as the authorities had not weighted the interest of the investigation. They were sufficient to override the public interest in the protection of the journalist's freedom of expression. She was awarded, under Article 41, 10,000 euros. That was her damages for this. Finally, we're going to look at a case that sought to prevent discrimination in Europe. And this case is called Orsius and others versus Croatia. So Orsius v. Croatia was a case heard before the European Court of Human Rights concerning activities of the Roma Gypsy population in schools in Croatia, which were held legal by the Constitutional Court in 2007. So the Croatian government had created special schools for the Roma population. They said that the Roma children needed additional schools, that they needed to be protected, that they needed this. And they were being schooled separately from Croatian children. So now we'll see how the Romas felt about this. So this got the majority in the Croatian courts found that they were, so this got to the European Court of Human Rights, and they found that the Roma children were not sufficiently protected by safeguards that would ensure their education, and that the state did have a duty to their special needs as a disadvantaged group, and that the result of the arrangements that they were placed in separate classes and had a special curriculum completely different from the Croatian national curriculum was okay, except for the fact that owing to the lack of transparency and clear criteria regarding the classes, the applicants stayed in Roma-only classrooms for long periods of time. According to the evaluation, so that the European Court of Human Rights found against Croatia and said that this was unfair, this was discriminatory, and that this could not be upheld. So the case was returned to Croatia, and Croatia is supposed to make changes. 2 years later, after the case has been returned to Croatia, the European Court sends a team out to see what changes have been made. And this was their comment in 2010. The situation in the schools remains the same. The majority of Romani children continue to attend Roma-only classes. There was no change for the applicants in the Orsius case. And to this day, there has not been a change. Amnesty International filed a submission with the European Council. And I think we discussed this, last time about bringing in amicus curiae to support. And in this case, it's only due to the efforts of Amnesty International that the case of Orsius versus Croatia is still active, and that there's still a push to allow Roma children to attend regular Croatian schools. I'm now going to move into the issues that I was asked to discuss by one of the participants, and that is concerning how the European Court of Human Rights has dealt with detention. I don't know if you want to do some questions now, maybe on the material that I've covered, or if you would like to allow me to continue on to discuss. I'm going to go now into specific laws that cover detention issues. And then I'm going to go into specific cases that deal with, that the European Court of Human Rights has dealt with detention issues. Victor, do you have any questions?
Yep. I just dropped the message in the chat. If someone has questions, please ask them via chat or here in person. Если у вас есть вопросы, можете их задавать.
I mean, in this session, I have just picked specific cases that illustrate essential rights that the European Court is trying to protect. If when we're apart for 2 weeks or 3 weeks, you think of other issues and other areas other than detention, which we're going to focus on now, I am more than happy to look at those issues.
And cases that you've discussed, I dropped the link on those cases on the website of the European Court or Wikipedia, so that people can come back and revisit and read about them a little bit more in depth.
Great. Okay.
It doesn't seem like we have question. Pavel says everything's clear, so
Okay.
I guess we can move forward.
I will proceed. So I'm going to first discuss where are the rights on protections from detention coming from? So you have in the European Convention on Human Rights, Article 3, which prohibits torture. It states, no one shall be subjected to torture or inhumane or degrading treatment or punishment. In Article 5 of the European Convention of Human Rights, you have the right to liberty and security. Everyone has the right to liberty and security of person. No one shall be deprived of his liberty, save in the following cases in accordance with procedure prescribed by law. The first is lawful detention of a person after conviction by a competent court. The lawful arrest or detention of a person for non-compliance with the lawful order of a court or in order to secure fulfillment of any obligation prescribed by law. And 3, the lawful arrest or detention of a person effected for the purpose of bringing him before competent legal authority on reasonable suspicion of having committed an offense when it's reasonably considered necessary to prevent his committing an offense or fleeing after having done so. The detention of a minor or lawful order for the purpose of educational supervision or for his lawful detention for the purpose of bringing him before the competent legal authority. 5, the lawful detention of persons for the prevention of spreading diseases, the persons of unsound mind, individuals affected by alcohol or drugs. The lawful arrest or detention of a person to prevent his effecting an unauthorized entry into a country of a person against whom action is being taken with a view to deportation or extradition, a temporary holding. Everyone who is arrested shall be informed promptly in a language which he understands of the reasons for his arrest or any charges against him. Everyone arrested or detained in accordance with provision 1 of this article shall be brought promptly before a judge or other authorized, so not sit in jail for 2 years like the British did, or other officer authorized by law to exercise judicial power, and shall be entitled to trial within a reasonable time or to release pending a trial. Release may be conditioned by guarantees to appear for trial. Everyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court and his release ordered if detention is not lawful. Everyone who has been the victim of arrest or detention in contravention of the provision of this article shall have enforceable rights to compensation. So now I've laid out the rules that the European Convention of Human Rights has in protecting prisoners. There has to be a justified reason for detaining somebody. That person who is detained has to have a right to seek counsel. That person has to have a limited amount of time there. They have a right to a speedy trial. And if these rights are violated, then that person has a right to seek compensation. Now, when you're looking at the rights of detention, you have the rights of the European Court that are laid out, as I've stated them, the European Convention of Human Rights, but you also have the International Covenant on social political rights that was passed by the UN and that countries are signatories to. And this is the basis for all international courts and how they decide on when they draft their statutes on what are the rights to detention. And in looking at this, I didn't just look at the detention rights. I looked at the other laws the other rights that are guaranteed, that are affected, that are implicated and affected directly by detention. And the first one is the right to be presumed innocent. This is an essential right under Article 14. Everyone charged with a criminal offense shall have the right to be presumed innocent until proven guilty according to law. What are the indicators that this right is being violated in a domestic court? Public comments by the judge, lawyers, government of the defendant being guilty. And I've seen this in Russia, and I've seen this in other countries, defendants being held in cages with heavily armed guards next to them. That violates the presumption of innocence. That automatically creates an impression for the media, for juries, if you're having a jury trial, that this individual needs to be held in a cage, that he's so dangerous that you have to have armed guards there with machine guns. Another indicator that this right is being violated, that the judge makes statements that suggest the defendant is guilty of the crimes before the verdict is even reached. Public authorities, such as government officials, prosecutors, or police, saying or doing anything to suggest that the defendant is guilty before the verdict is announced. This could, for example, be shackling him, so holding him with what are they called? Arm cuffs, handcuffs. Too many languages in my head. With handcuffs in a cage, or bringing him into court that way, automatically create the impression that this is dangerous, that this individual is dangerous, and that this could also lead to prejudicial impressions to the press, to the jury, to individuals in the courtroom. So the prosecution has the burden throughout the trial of proving guilt. And so the prosecution expected to produce evidence to back up its allegations, that no one suggests the defendant has to prove himself innocent. When you put a defendant in these positions, you are creating an assumption of guilt. And I'm only raising this in the detention context because this goes towards fair detention and the rights of detention. You are using detention to apply a lack of innocence. So this is a violation of the International Covenant on Political Rights, but it's also an essential part of a fair trial that the European Court of Human Rights has also judged under theirs. So it is an international standard that we should all everywhere be looking at our courtrooms and seeing whether these rights are being violated, because they're automatically going towards implications that of a defendant and violating their rights to be considered innocent. Pretrial detention under international standards should be an exception rather than the rule. For example, if the person is so dangerous, he is so wealthy that he can get on a plane, he has private jets all over the country, he can fly away, those are reasons for pretrial detention. Not simply this person's an inconvenience, we need to keep them quiet. That is not a reason for pretrial detention. The authorities may not make statements about the defendant or present the defendant in a way that makes them look guilty. Another right, which right to be presumed innocent, now it directly affects your detention rights, as does the right to remain silent. So I'm going through different rights that are impacting on a defendant's detention and how he will be considered by the court. And under Article 14 on the International Covenant on Civil and Political Rights, the termination of any criminal charges against him, everyone shall be entitled to the following minimal guarantees in full equality: not to be compelled to testify against himself or confess guilt. Normal person won't do, like, if you're brought and you're not guilty, why would you confess? There's numerous reasons. There's physical coercion, being beaten, confessions being beaten, and we're going to look at specific detention cases that deal with that. But there's also psychological coercion. Impermissible psychological coercion may include, for instance, just threats of violence, uh, exposing the defendant to violence against his family member, threatening a family member, prolonged incommunicado detention, um, locking somebody by themselves for months, sedating a defendant with drugs or alcohol. There's numerous ways that a defendant's detention can be used to violate his right to remain silent. Another right under Article 14 is the right to a speedy trial. So in the termination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality: to be tried without undue delay. The right to be tried without undue delay aims to avoid keeping defendants from being held too long in a state of uncertainty about their fate. This right also serves the interests of justice, as an unduly lengthy trial jeopardizes effectiveness of a court, credibility of justice, and the availability and quality of evidence that may deteriorate with time. The right is also important for persons in detention to ensure that their deprivation of liberty does not last longer than necessary. The longer you keep somebody, if you're keeping an individual for a crime for 3 years in a prison, that is 3 years of witness statements that are aging. That is eyewitnesses that are beginning to forget. This is a diminishment of the judicial process. Prolonged pretrial detention may, at some point, and this has been found by the European Court of Human Rights, create completely arbitrary detention. When it becomes completely nonsensical, the length of time that an individual is being held in relation to the length of time to prepare his case, to hand materials to the defense, all of that, when it becomes completely illogical, it can be declared that the detention is not, that it is arbitrary detention, is no longer legal. What are the indicators of this? First of all, is there a delay in the start of the trial of 1 year or more since the arrest or charging of a defendant? Now, in US cases, this would be very unusual, and almost never happens unless it is an extraordinary complex case involving, paperwork and taxes, and both defense and prosecution need that length of time to go through the materials. Having worked for 20 years in international courts, this is normal. This is normal, sadly, that defendants are held, and that they are held from sometimes a year to 2 years before any trial commences. But there is no time proof of definitive delay. There have been delays of 6 months that the European Court of Human Rights has felt to be wrong and undue. In other circumstances, where these factors are cut the other way, maybe of 11 years, was not held to be undue because of the complexity and the issues involved. So deciding whether it's too long, deciding a lot of these issues of fairness of trial, fairness of detention, will be based on individual factors of the case at all times. An additional indicator is, are there multiple defendants? To make sure that each defendant gets each individual gets a fair trial requires coordination among defense lawyers and defendants, and also with the prosecutor. And that can lead to a longer trial, that can lead to a more complex trial. Also, has the defendant requested the delay? If the defendant's requested the delay, the whole issue becomes moot, because it's his choice that he needs additional time to prepare his case. And then, is the defendant being detained the entire time before a trial? The effect of the delay on the defendant is a relevant factor. Where there will be prejudice to the defendant, or the defendant is being held in detention during the period, the defendant has to be tried as quickly as possible. It's all more important where the defendant is deprived of his liberty than whether he's allowed out on bail, he's allowed to work on his case from his own home. There's a different standard in terms of the expedience of a trial. The UN Human Rights Committee has specifically stated that where the defendant is denied bail by the court, the defendant must be tried in as expeditious manner as possible. Another right that impacts the right to detention is the right to be informed of charges. If a defendant is not aware of what he's being charged with, they won't be able to prepare their defense. They won't be able to prepare for trial, and they will be at a significant disadvantage. Article 14 also states, in the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees: to be informed promptly and in detail in a language which he understands of the nature and cause of charges against him. In general, defendants have the right to prompt access to counsel. This has been interpreted to mean within a couple of days after arrest or detention. Denying access to counsel may amount to arbitrary detention as well, when it impedes the capacity of a person to challenge their detention. So when can a defendant speak with their lawyer? It has to be quick in order to ensure the fairness of his detention, but it also has to be, they're obliged to provide all defendants with adequate opportunities, time, and facilities to be visited by and to communicate and consult with a lawyer without delay, without interception, so no monitoring of their time that a defendant spends with their lawyer, and no censorship, and in full confidentiality. So it's not enough. First of all, it's essential to be allowed to see your lawyer. If that's not allowed, you've violated rights of detention. Second, when you see your lawyer, it has to be in full confidence and in full privacy. This cannot be a monitored a situation where the meetings between the defense lawyer and the defendant are monitored, because that further is a breach of the individual's right to detention and fair trial. Article 10 says of the International Covenant of Civil and Political Rights says, all persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. Detention of an individual before trial must be the exception rather than the rule. It must be necessary to prevent flight, interference with evidence, or recurrence of crime. Those are the only reasons to detain somebody before their trial, the entire time before their trial. And pretrial detention must be based on individualized determination that is reasonable and necessary, taking into account all of these circumstances. Although a full examination of conditions of detention is beyond the scope of what we're looking at, you should report insofar as possible on the conditions of your defendant. You should monitor insofar as possible your defendant's detention before and during the trial. This is relevant on its own merits, as the individual should never be subject to conditions amounting to torture, cruel, inhumane, or degrading treatment. So as an attorney, as a human rights official, as a defense lawyer, when you meet with your client, it's essential that you look around and see the room. What is going on here, and keep a record if you're going to be bringing this up as an issue of how this individual is being held. The conditions of a defendant's detention may bear on their right to a fair trial. For instance, abusive conditions of detention could be used to elicit a confession or deny a defendant access to trial. So I've said before, detention is not just detention. Detention isn't just, oh, he's being held badly. This is not fair. I'm going to have to, file a claim in this. The abuse of detention creates the abuse of other rights, and the abuse of these other rights, presumption of innocence, the presumption that your ability to not, your right not to testify against yourself, all of these things can be manipulated and changed. All of these rights can be affected by the treatment that an individual receives when they're held in detention. Well, the focus here is on ways that abusive conditions of detention may affect fair trial rights. Another issue is about the welfare of the defendant. It has to always be reported to external sources. If you're a government or your courts, if you cannot go directly through the courts, or the courts are ignoring it, there should be a monitoring system put in place to monitor the welfare of the defendant. So that means it does physical, like how does he look physically? Is he in such a state of suppression, what is going on with this individual, because these are all violations of detention, and they have to be brought to the um, attention of the court system, of the media, of anybody that can become aware of this. And if there is an instance that this case will be brought to an international court or to a European Court of Human Rights, the role of an NGO, the role of a defense lawyer is essential, because that's the person, and those are the individuals who are going to be providing and gathering images and evidence of what's going on in detention. And this means everything from hygiene in the detention facilities to the state of the defendant. Another area where there's an abuse in detention is the administration of bail. And that's something that I think NGOs and defense lawyers have to be aware of. You should not need to seek special means or access to receive bail for your client. This should be a standard process that's followed at all points throughout the trial to ensure that your defendant can defend himself from outside of a detention facility. Another factor to look at when dealing with somebody who's being detained is to examine, is there any different treatment of this individual as compared to the other people in the detention facility? So if you have access to the detention facility, is there anything that you can spot that based on their gender, based on their race, based on their religion, political affiliation, disability, sexual orientation, gender identity, any of those reasons that this individual is being held or treated differently, that has to be monitored, that has to be documented, because that's also something that could be brought forward later on when his or her detention is challenged. And I did touch on this before, but solitary confinement is a very something that should be monitored, and the reasons for it, the reasons that the court is stating, and the duration of the solitary confinement. Again, as I've stated, it can be used, solitary confinement, it can be used to break an individual in order to get a confession out of them. Okay, so now I'm going to go really quickly into something called the Mandela rules. And these are now considered universal rules for examining how somebody is being treated in detention. And I can pull up, let me just note that to myself and send that the original document. If I don't know if there must be a Russian.
Andrea, I would like to, yes, I'm
Okay.
looking to share it. Is it the United Nations rules of Mandela?
They're called, yes, the United Nations rules, the Mandela rules. So
Okay, got it.
I'm gonna just do an abbreviated because I want to get into the cases today before we finish that are revealing how the European Court of Human Rights has dealt with detention. So the first one
Got it.
is the placement of a prisoner in a dark cell with complete darkness. Is there corporal punishment? That's also not allowed. Reduction of their diet or drinking water. One of the ways that prisoners are often broken down is by completely restricting their food, so that they're at such a weak point that it makes it easier for whoever to manipulate them into a confession, manipulate them into admissions of things that they may not have done or may not have been involved in. And also collective punishment. So finding that as a whole group, this individual's guilty because he's part of a group. So the UN Human Rights Committee and European Court of Human Rights have held that prolonged solitary confinement does violate the prohibition against cruel, inhuman, and degrading treatment. Under the Mandela rules, solitary confinement is holding a prisoner 22 hours or more a day without meaningful human contact. So it's one day. which, this in many countries, it is much, much longer. Another thing to look for under the Mandela rules is not being appropriately protected from ill treatment by other cellmates or prison officers, forcing the individual into an area in the prison where, for example, that there's that as a Muslim, as somebody who's gay, as whatever reason, that there will be a group of people who will attack him. So, or allowing him just to be put in positions where his life is put at risk because of the prison guards suddenly disappear when he's left with dangerous prisoners. Another thing to look for is repeatedly being transferred from prison to prison. So shifting this individual's area where they're meeting with their lawyers and stuff, making it more difficult, changing it's all going towards some manipulation of their mental health. Strip searching in conditions that implied suffering and humiliation and that go beyond what's expected if somebody is confined. Again, being in a small cell. I'm going to try to skim through this so that we can get to the cases. According to the European Court of Human Rights, defendants must be detained in conditions that do not unduly limit their ability to prepare for their defense. Because if they can't read or write within a reasonable degree of concentration, or become excessively tired or restricted from seeing their lawyers or are kept in dark rooms, they're limiting their ability to prepare for their own defense. The court has to always consider where there are less restrictive measures, short of imprisonment, that can ensure the appearance of a defendant in trial. This can be house arrest. This can be surrendering a passport, GPS ankle bracelets. There's numerous ways to allow a defendant to prepare his defense in his own home without, or outside of prison, without risking the security of other people. So I'm going to go through a number of cases that went before the European Court of Human Rights. One, two, let me see. So I have 2 Russian cases, then I have an Estonian, and then I have one in the Czech Republic, Poland, Latvia, and then one in Belgium. And we're going to discuss just a little bit briefly the Navalny case in the context of the Belgian decision. So I'm hoping, I think we could do this, yeah. Let me go back to the first case. So some of these may be familiar with for you, some may not, if it's all depending on your involvement in as lawyers, if you are lawyers or not. But the first case, and I hope I pronounce it right, is Shimovolos versus Russia, and that was brought to the European Court of Human Rights in June of 2011. The applicant was detained. It's spelled Shimovolos. The applicant was detained on his way to a demonstration. He did not commit any offense. However, the government claimed he was arrested in order to prevent him from offending. The applicant complained that this amounted to a deprivation of his liberty. Relying on Article 5 and Article 8 of the European Court of Human Rights, he complained that his arrest had been unlawful and that his name had been registered in the surveillance database in Russia. And as a result of that, the police had collected personal data about him, and that was the basis of their arrest. They observed the European Court observed, and so it went forward under the right to liberty and security under Article 5. This is the first section that they look at, that the court examined. The court observed that Mr. Shimovlos had been taken to the police station under threat of force and had not been free to leave without their permission. He had been deprived of his liberty, and it was at that point, the first time he was arrested was only for 45 minutes. However, the police had not suspected him of committing offense. Instead, he had been arrested, according to government submissions, in order to prevent him from committing an offense because he was a member of a human rights organization or considered an extremist. It appeared that he had not been stopped, questioned, and escorted, that he had been stopped, questioned, and escorted to the police station in Samara because his name had been registered in this database. The court recalled the convention, and specifically Article 5.1 did not allow detention as a policy of prevention. You cannot arrest somebody in order to prevent them from being involved in a demonstration. So people were perceived by the government authorities, rightly or wrongly, to be dangerous or likely to offend. The government's explanation that he could commit an offense was not specific enough to be acceptable under the convention. The only specific suspicion against him had been that he might have been carrying extremist literature, yet no evidence provided showed that he had anything on him. Apparently, the court noted with concern the suspicion had been based on the mere fact that he was a member of a human rights organization. The court emphasized that membership of human rights institutions could not justify a person's arrest. He had been arrested arbitrarily in violation of Article 5. And he now sued also under Article 8, which is a right to respect for private life. So being involved without his knowledge, being listed in a database. I believe it had the facial recognition data as well on this individual. The court noted that by collecting and storing data about the movements of Mr. Shimovlos by train or air, the Russian authorities had interfered with his private life. In order for that interference to be justified, the court recalled minimum safeguards had to be set out in a statute or law to avoid the abuse. The database in which his name had been registered had not been created on the basis of a ministerial order, which had been publicly published and was not accessible to the public. So nobody knew of. So there was the lack of knowledge that this database existed and that there was no public law creating this database. Therefore, people could not know why individuals were registered in it, for how long the information was being kept, or what type of information was included, how the information was stored, and who had control over it or who could see it. None of this was known to the individual, which meant that they couldn't have never challenged the database or having their name being placed in the database. As a result, the scope and manner of collecting and using data in the surveillance database had neither been clear, foreseeable, or contrary to the convention in violation of Article 8. So they held that his rights were violated in this case. And what the reason that I included this case is that the factual basis of this, that the crux that this case was brought to the European Court of Human Rights was on 45 minutes of detention. So 45 minutes of detention based on what the court found to be illegal reasoning, preventing future crime, use of this database, that the defendant had no knowledge of. All of this came out of a 45-minute detention. Second case we're going to look at is Kopylov versus Russia, Kopylov, which was decided 29th of July 2010. So in the January of 2001, the applicant to the court, to the European Court, was arrested and escorted to the Interior Department of Lipetsk region in Russia. And it appears from a report from the arresting police officer that he was arrested as a suspect of drug trafficking, but no drug-related charges were ever brought against him, and no drugs were ever found on him or in his possession. According to the applicant, he was told that he was suspected, when he got to the prison, he was told that he was suspected of murdering a policeman, even though he denied all involvement. In that same evening, he was transferred to another police station. I'm not going to try to pronounce that. It's like 20 letters, where he was beaten up by the head of the police. According to the applicant, they slapped and kicked him in the head, trunk, and solar plexus. They forced him to kneel down in front of the picture of the murdered policeman and to apologize for killing him. They undressed him, they stripped him, and threatened to rape him. He smacked his hands over, the policeman smacked him over his ears. He was smacked so much in the head that he lost consciousness and was handed over to the police officers, who continued to beat him. They tied his hands behind his back with a rope and hung him. Then they put a gas mask on him and blocked his air vents, so he was unable to breathe. They also tortured him with electricity. The prosecutor's office, when he brought this case of what happened to him, they questioned the prosecutor's office questioned 3 of the police officers. They testified that the applicant had not been subjected to any treatment. So all 3 police officers involved in this clear torture denied any involvement. The prosecutor's office refused to initiate criminal proceedings against them because they said that they denied it. The decision was set aside by the prosecutor's office, and an additional inquiry was conducted. They were able to establish his time period in the different police stations, and medical examination was performed. Yet again, even citing damage to the individual, injury to the individual, and establishment of his presence in this, the prosecutor's office of Yelets again refused to initiate criminal proceedings. The applicant complained to different courts and different prosecutors from January through April of 2001. That between January and April 2001, he had been repeatedly beaten. And he relied on Article 3 of the European Convention that states that no one shall be subjected to torture or to inhumane or degrading treatment or punishment. This case arrived at the European Court of Human Rights, and it said that there was a clear violation of Article 3 of the Convention on account of the authorities' failure to investigate effectively the applicant's complaints of his ill treatment from January to April 2001. So not only were the police officers who committed the torture liable, but the prosecutors' offices that refused to investigate and refused to listen to and take into account the evidence that he submitted of his torture were all found to be culpable. And it held that the violation of Article 3 Convention on account of treatment, a clear violation of Article 3 based on the treatment of the applicant. And they decided as well that on account of the failure to investigate, that the state had to pay the applicant within 3 months of the date. He was awarded 105,000 euros, plus any tax chargeable in respect to the damages by the Russian authorities. I believe he has not been paid, but that was the European court. So this was a clear example of torture during detention, which is clearly banned. But I want to focus your thoughts on not just that this individual was tortured in detention, but that the European Court of Human Rights focused its decision on how the prosecution office, how the following investigators dealt with the allegations that the defendant made, and that the fact that they ignored all of his evidence that he brought forward of what had occurred to him was the reason that this case ended up and was found in his favor by the European Court of Human Rights. The next case is Mikhailov versus Estonia. Mikhailov is spelled Mihhailov versus Estonia. Alexander Mikhailov was stopped by police officers in a city called Narva. The officers attacked him because they did not like his behavior. They beat him in his head, again, making him lose consciousness. He woke up at the police station. Again, he was beaten, later taken to hospital. The authorities refused to open any investigation into this case, and they only started one after serious delays. The investigation, once it was started, failed to collect evidence such as witness testimony from people who had seen what happened, video recordings from the police station. Despite failing to obtain or examine the relevant evidence, the investigation rejected his complaint. When the case arrived in Strasbourg at the European Court of Human Rights, the court ruled that investigating authorities had not been independent, as the police officer in charge was a police investigator from the same regional substructure of the police force as the police officers implicated in the events. The investigation also failed to gather crucial evidence or properly justify their conclusions. So the issues that the European Court of Human Rights focuses on is not just the bad treatment. That can be held, that people can be found accountable in national jurisdictions and punished. This happens clearly, as you all know, in the United States and everywhere, but there has to be judicial remedies and investigative remedies. The fact that the investigator investigating the charges that Mr. Mihailov had brought was part of the same police force as those investigators who had attacked him was found to be a conflict of interest. And so that the court found that it was an improper investigation into the alleged crimes. The separation of relevant investigative and prosecuting bodies within the Ministry of Interior and Ministry of Justice in all countries helps to guarantee the independence of investigations. And the European Court's decision was put forward as part of a demand to have these, to ensure that Estonia changes and establishes that sort of separation of authorities within ministries and within actual investigative and police bodies. Kummer versus the Czech Republic, 2014. Kummer is spelled Kummer. Vladimir Kummer was a dental technician, and in May of 2010, he was walking home from a bar and was stopped and arrested by the police for supposedly urinating in the street. They asked for his identity card, and he allowed them to come to his home to collect his identity card. Instead of going back to his home, they took him to the police station. At the police station, he was shackled, his arms were tied, he was punched in the back of the head and in the face. He was left hanging with outstretched arms that were shackled to two different walls. And after 30 minutes in this position, he was told he could go home. As a result of his injuries, he wasn't able to work for 16 days. A criminal investigation concluded that police officers had done nothing wrong. A later report by the ombudsman found that the police officer had committed a disciplinary offense, but there was no finding that he'd been physically ill-treated. Given the evidence before it, the European Court could not rule on whether he'd been beaten or not. However, due to the painful and unnecessary way in which he had been left hanging by his arms in the cell, the court concluded he had been subjected to degrading treatment. The court also found that the investigation into the incident he had suffered unnecessarily from delays, and it had not been properly independent. His right to an effective investigation into the breach of his rights had also been breached. So not only was he physically tortured, but he had also not been allowed to properly bring this case and have it be investigated by the Czech authorities. Following this and another case, a series of reforms took place to ensure that effective investigations into allegations of police ill-treatment. In 2012, the Independent General Inspection of the Security Forces was set up in the Czech Republic to investigate crimes allegedly committed by police officers. In 2013, and I'm going through this just to show when a decision by the European Court can have an impact and when a government responds directly to the decision by a court. Further, in 2013, the Constitutional Court of the Czech Republic changed its case law. Courts must now consider in more detail whether allegations have been effectively investigated. The European Court's judgment in this case was translated into Czech, and it was sent to all heads of relevant public institutions of the Ministry of Interior, individual police departments. This and other international human rights standards on the treatment of detainees were included after this decision in all police training sessions in the Czech Republic. The police president ordered an inspection of all police cells in the Czech Republic to ensure that there were no iron rings installed in them where they had hung him. In 2015, the police president changed a binding instruction to police officers to specify that shackling a person to a fixed object should only be done if needed to prevent dangerous conduct. The use of such restrictions in cells is now only allowed in exceptional circumstances. Mrozowski versus Poland, 2009. Mrozowski is spelled Mrozowski, Mrozowski versus Poland. Artur Mrozowski was on the train home from work when police officers entered his carriage, responding to some disruptive behavior in the carriages by football hooligans. He was supposedly calm and sober, and he was not even in a part of the group of football supporters. Nevertheless, a police officer repeatedly beat him in the face with a truncheon before he was laid out on the platform. The attack knocked out 3 of his teeth and cut open his face. He spent the night in hospital, suffering from nausea and extremely ill. The police then pressed charges against him, falsely claiming that he had been one of the violent hooligans. The Polish court acquitted him because he had been sober and peaceful all along. An investigation found the police officers, however, had done nothing wrong. So even though the court found that he had not been a violent hooligan and not been involved in any crimes, the court also found an internal investigation by the police department in Poland found that the police officers had done nothing wrong in arresting him and in beating him. The European Court ruled, let's just see what the date was. This was in 2009. The European Court ruled that Mr. Mrozowski had been violently assaulted by police officers without any justification. Further, the investigation into the officers' actions had not been independent and was woefully inadequate. Criminal proceedings were brought against the police officer who carried out the attack. He was found guilty and sentenced in July 2012. The European Court's judgment was one of a series involving police brutality in Poland. Following these cases, comprehensive reforms were carried out to help prevent and properly investigate such incidents. These included changes to the law, education, training of police officers, a new institution to monitor and prevent police misconduct. In particular, a new law came into effect on the force by police in 2013. This took account of the case law of the European Court, which is very important and interesting, that a national court, that a national legislation in passing a new law cites specifically to a case brought by that country, a citizen of that country, to the European Court, stating that the police's use of force must be proportionate and as limited as possible and only when genuinely necessary. The next case is Kadikis v. Latvia. Kadikis is spelled Kadikis. Arnis Kadikis was sentenced to 15 days detention for a minor offense. He only served his sentence with 4 other detainees in a cell measuring 6 square meters. There was no window, there was no ventilation, and he was not allowed out in those 15 days. As a result, Mr. Kadikis saw no daylight and had no access to fresh air for 15 days. There was no mattress, there was no blanket, there was no bedding. He was given only 1 meal per day. The court ruled that these conditions amounted to degrading treatment, violating Mr. Kadikis's right. New legislation introduced minimum standards for detention conditions. These included a minimum amount of living space, as well as a requirement that detainees have access to natural light and a bed. new detention centers were opened and old ones were renovated in order to meet these standards. So there was again a direct impact on the basis of the decision by the European Court of Human Rights on detention standards in Latvia. I'm going to throw in now just I think one case to deal with freedom of speech and how the European Court of Human Rights, because this isn't one of the ones that are counted as the significant ones that changes standards in the European Court of Human Rights, and it's also not dealing with detention, but I think it's relevant to the work that many of you are doing. So in 1995 in Belgium, a huge operation was carried out to search the workplaces and homes and cars of journalists. It involved 160 police officers. The warrant had been given the officers almost unlimited scope to seize documents and objects without specifying where the search could take place or what seizures were for. The search was related to the prosecution of government employees for leaking confidential information. However, none of the journalists involved had even written any articles containing state secret information. They were not accused of any offense or told why the search was happening. So clearly they were looking for some sort of link between the journalists and the officials who had leaked the information. The European court ruled the searches and seizures had been disproportionate, that they'd violated the applicant's right to privacy and their right to provide and receive information as journalists. This led the Belgian parliament in 2005 to adopt a law on the protection of media sources. This made it illegal to seek information about journalist sources, in particular through search or seizures in the majority of circumstances. So the Belgian authorities reacted directly by changing the law after this case had been decided by the European Court of Human Rights and in favor of protecting journalists' rights. So I am aware that in Russia, the changes of the laws in 2020 gave Russian constitution precedence over rulings of international bodies, as well as international treaties where they come into conflict. So this is, of course, an enormous impediment to something like what we've seen happen in Latvia, Poland, Czech Republic, and Belgium. However, there are means such as I started today's session with, looking at bringing cases, lump cases that are connected together before the European Court of Human Rights. Also looking to just bringing the publicity of that, especially if you can show high numbers of cases that are identical. Abusive detention in 300 different cases shows that there's a serious lacking in the protection of defendants and detained by the national legislation, by the courts, by the police, so that there is a way to bring at least publicity to an issue, especially if you can bring it in that group, by bringing together groups of cases. Now, the European Court of Human Rights, I'm going to just check what the date was, 20th of January 2021, did issue some decisions on the Navalny case. And we talked about that a little bit. Somebody asked me about that at the last session that we had. And unfortunately, their decisions and their I'm surprised. The basis that the European Court has issued its decisions on the Navalny case were Article 34 of the European Convention on Human Rights and Article 39. And I'll read to you what Article 34 says. Individual applications. The court may receive applications from any person, non-governmental organization, or group of individuals claiming to be the victim or violation of a high contracting party of the rights set forth in the Convention and Protocols. The high contracting party undertakes not to hinder in any way the effective exercise of this right. On the same application, They applied under 39. So they decided that he had a right. So that was the first decision in the Navalny case by the European Court of Human Rights. They decided only that he has a right to bring a case before the European Court of Human Rights. Nothing else has been decided. The other basis that they brought it was Article 39, which is article called friendly settlements. At any stage of the proceedings, the court may place itself at the disposal of the parties concerned with a view to securing a friendly settlement of the matter on the basis of respect for human rights as defined in the convention and protocols thereto. Proceedings conducted under paragraph 1 shall be confidential. If a friendly settlement is affected, the court shall strike the case out by a list of decision, which shall be confined by a brief statement of the facts and the solution reached. The decision shall be transmitted to the Committee of Ministers, which shall supervise the execution in the terms of a friendly settlement set out in this decision. So all that the European Court of Human Rights issued in their decision, which hasn't been reacted to by the Russian government, has been that he had a right to bring a case and that there was a chance for a friendly settlement, that this case could have been settled within the European Court of Human Rights. There has been no decision on facts. There's no decision on the governmental behavior. There's been nothing other than those two very simple administrative decisions in the Navalny case. So I'm going to open up now for questions, and I've left you with a lot. I've left you with everything from, looking at specific cases brought before the European Court of Human Rights in terms of pilot judgments, a number of cases that establish essential tenets of the European Court of Human Rights, from freedom of religion to detention matters. And then I focused on different laws outside, including the European Convention for Human Rights, but also international standards, which are laid out in the International Covenant of Civil Political Rights, UN document, that define what is detention and what are the rights that can be impacted by improper detention. And then I concluded by going through specific cases that have been brought before the European Convention for Human Rights, and that dealt with the issues of detention, and at almost all points have dealt with it in terms of not the beating, not the actual act, but in terms of how did the nation's ministries, courts deal with the violations of detention. So that is the crux for the European Court of Human Rights. Where can we change this? And as we've seen in a number of these cases, they have been able to affect change when the country listens and when the country is receptive.